a comparative law decision from China and Canada. And please, you can start your presentation.
Yeah, everyone. Today I'm very honored to be here and thanks for the invitation. And I briefly present my working paper on public policy and overriding mandatory use in international commercial contracts with a comparative focus on China and Canada. And today I will focus on 4 points: research problem, research questions, my main conclusions, and how choice a lot Dataverse helps me conduct this research. So first of all, my research problem is how do Chinese and Canadian courts differ in their judicial use of public policy and overriding mandatory use in international commercial contracts? This question matters because, as we all know, party autonomy is a basic principle in international commercial contracts. Parties are free to choose their applicable law. However, this freedom is not absolute. There are 2 important limitations. They are public policy and overriding mandatory rules. So here are 3 specific research questions. How are these doctrines formulated in the 2 legal systems in theory? And how are these doctrines applied in judicial practice? And finally, what are the main similarities and differences between the 2 systems? Why China and Canada? First, both of them are major economies engaged in cross-border commerce. And second, their connection involves trade, investment, and other cross-border economic activities. And recently, Canadian Prime Minister Carney just announced that Canada will deepen the political and economical cooperation with China. So this makes the comparison is not only hypothetical, it's very practical. And finally, China and Canada have very interesting comparative pairs for because the courts offer because they have 2 different legal systems. China have a codified civil law system, and Canada has mixed legal system combining Quebec provincial civil law system and other common law judicial and jurisdictions. So my main conclusion is even though in theory both of legal systems recognize these 2 concepts, in practice the judicial use of these 2 concepts are very different. In China, historically, courts were more willing to use these 2 concepts. However, recently, courts are generally narrowing the use of these 2 concepts. And the blurry between these 2 concepts are not always very clear. And we found out that the courts always use these 2 concepts in their judicial report. And we also found out there is strong connection between public policy and overriding mandatory rules with its national regulational goals. And for Canada, the picture is very, very different. When we confine it to international commercial contracts, the amount of relevant case law is extremely sparse. So the amount of case law is very limited. And therefore, it's very hard to find out if there's a clear boundary between these 2 concepts. And sometimes the courts don't even use the concepts. They don't use the name. And finally, and it's not until very clear whether what is the main pattern of the Canadian courts when they use these 2 concepts. So next, like the central part of my presentation is how the choice a lot Dataverse helps my research. And it helps me to conduct research in three ways, from a doctrinal overview and to legal sources, and finally to case law. And step one is I start by reading the jurisdictional report across different countries, which are China and Canadian common law jurisdictions and Canadian Quebec civil law system. So I can just go to the section who deals with public policy and overriding mandatory rules. And there I have a very clear idea that both of these two countries, the three jurisdictions, they recognize the existence of two concepts. And second, I will identify legal instruments. For example, for Canada, we already knew that it's common law like jurisdiction. So after finding out this legal instruments, we can realize that there's not a codified instrument for this issue. And for China, it's there are at least relevant instruments and where we can find the law of application law to foreign related civil law, which is the very most important instrument. And we can also find some Supreme Court interpretations on these two concepts. And finally, yeah, I think, and similarly, we can find out relevant legal provisions in Quebec. Yes, and that is the Civil Code of Quebec, and which is very comprehensive. And go back. Yes. Yeah, the step three is to identify case law as starting points. And here we can find some relevant case law decisions just dealing with public policy and overriding mandatory rules directly. And the case listed here are not exhaustive, but they are very useful as an entry point. So further, I can go to like more research into other databases like Chinese national legal database or like Westlaw and yeah, and so they cannot replace other countries' completed data set, but they are very useful as a research tool because at least they give you some ideas and like some very important case law decisions. So why the Dataverse matters for scholars? I think it's not only matters for my project, it also matters for other comparative scholars. And first, it saves time, yeah, obviously. And second, it makes question by question comparison across jurisdictions much easier. And third, it connects doctrine, legal instruments, and case law. And first, it helps generate new research questions by making visible both the similarities and differences across legal systems. So in my case, just after viewing the jurisdictional report across the three jurisdictions, I'm curious about, okay, so what's their practical law? Like practical role, like of the use of these two concepts. So that's all. So thank you for
I want to say a few words about your presentation. Thank you again. And I'm going to try to share the screen to congratulate your work specifically for China. So I was very lucky actually, because I was not expecting to get someone from a Canadian partner institution who would also be knowledgeable in Chinese case law, okay? And China, when we started, so from the gap, the first project to the second project, China was so complicated to get data or to, like I have no knowledge of Chinese, and then you don't have access to the Chinese experts. The Chinese expert that we had in the project, the email doesn't work anymore. You cannot contact the person. It bounces back. All sorts of troubles.
Yeah,
So-
or more problems, even political problems, but I won't be able to explain those.
I'm so glad that Inc. came on board and you could not only help us with the North American part, but also the Chinese. And what I wanted to show, if I can close here and go back to the website, is that we have a list of our lesion cases and the number of cases as well. So lesion cases here and court decisions by jurisdiction, and you see that China is, highly ranked. And this is not a coincidence because Inc. did the work. And she found many cases and she says, oh, it's only a sample, but it's already a very good sample. If you don't have knowledge of Chinese or the Chinese legal framework, and it makes me so happy and proud to see, that your work is now available to the public, that it's helpful in terms of research. I think this was a marvelous tutorial to see how the platform can be useful to PhD researchers. Solomon Online, thank you so much, because it also shows how the theoretical framework or how the platform can spark new ideas, and you can find the data that you wouldn't otherwise have so easily in other places, specifically for Ghana or countries that you don't have the contact point, you don't know where to start. So I'm very proud of the work that you have developed with us. I hope that this partnership and collaboration process can continue and we can carry on. I wonder whether you have questions for Rorik, whether you have any remarks, and if the people here want to pose any questions to Solomon or Eve as well.
Just one remark regarding